Hello, my name is Seth Kim, and I am an associate here at Birch, Stewart, Kolasch, and Birch. On June 16, 2015, an en banc Federal Circuit decision held reciting a module in the context of a computer software patent did invoke means plus function claiming under 35 U.S.C. Section 112, paragraph 6, even though the operative word means for was not used. And under the invoked means plus function claiming, the relevant claim was indefinite for failure to disclose corresponding structure in the specification, such as an algorithm. The en banc decision explicitly overturned a decade's worth of case law that supported existence of a strong presumption of not invoking the provision of Section 112, paragraph 6, when the term means is not used. In this case, Plaintiff-Appellant Richard A. Williamson sued Defendants-Appellees Citrix, Microsoft, Cisco, Adobe, and IBM for infringement of U.S. Patent Number 6155840, quote, a system and method for distributive learning, which describes a virtual classroom environment. The district court decided the claims indefinite and invalid, even though the claims do not use the phrase means for, because the claims still invoked the means plus function rules under Section 112, paragraph 6. Since the term module was a non-structural nonce word, and further, the specification lacked a description of any corresponding structure. After a three-judge panel of the Federal Circuit entirely reversed the district court in all appealed issues, the Defendants-Appellees sought an en banc review, and the Federal Circuit sitting en banc reversed the three-judge panel on the Section 112, paragraph 6 issue and upheld the district court decision on the issue. The en banc decision acknowledged that prior decisions on means plus function claiming followed the Lighting World ruling decided in 2004, which presumed against invoking Section 112, paragraph in the absence of the term means, and that presumption was a strong one that is not readily overcome in the absence of showing that the limitation essentially is devoid of anything that can be construed as structure. But in Williamson, the Federal Circuit held that the strong presumption against 112, section paragraph 6 construction in the absence of the term means has led to a proliferation of functioning claiming untethered to Section 112, paragraph 6, and mandated a return to following the case law before the Lighting World decision. Accordingly, regarding the claim limitation of a distributed learning control module for receiving communications transmitted between the presenter and the audience member computer systems, and for relaying the communications to an intended receiving computer system, and for coordinating the operation of the streaming data module, as recited, the Federal Circuit said there is little distinction between the terms means and module, because module is a well-known nonce word that can operate as a substitute for means. That the prefix distributed learning control likewise fails to impart sufficient structure into the term module, and that nothing in the specification or prosecution history would lead the court to construe this expression as the name of a structure sufficiently definite to take the overall claim limitation out of the bounds of Section 112, paragraph 6. Thus, the Federal Circuit first held that the limitation distributed learning control module is subject to the provisions of Section 112, paragraph 6. Then reviewing the specification, the Federal Circuit stated that the specification of the patent lacks structure sufficiently corresponding to the coordinating the operation of the streaming data module function of the recited distributed learning control module, so that the claim was indefinite because of the absence in the disclosure of an algorithm for performing this function, which in computer implemented means plus function limitation is regarded as a sufficient structure provided by the specification. Thank you for joining me, and I hope you learned something today. Stay tuned to bskb.com for more upcoming videos of interesting cases and other commentary on intellectual property.